Well, it's election season once again, and time for more candidate conversations. I have in studio with me right now George Steele. He is running for District Court Judge. Hi, George. How you doing?
How are you doing? I'm doing fine.
Good, good. Thanks for coming on and talking with me.
Thank you for the invitation.
Oh, maybe a fist away. Okay, well, we'll start
How's
again.
that?
There we go. All right. That's fine. I messed up.
Glad this isn't live.
Me too. I messed up quite a bit. Quite a lot on the cutting room floor. All right, here we go. In 3, 2, 1. Well, it's election season once again, and time for more candidate conversations. I'm here with George Steele. He's running for Mason County District Court Judge. Hi, George. How you doing?
I'm doing fine. How are you?
I am well, thanks. And thanks for coming on and talking with me about this race.
Thank you for the invitation.
First things first, tell us a little bit about yourself. I know you're currently the judge for the municipal court in Shelton and the pro tem for the district court. But what else can you tell me about yourself?
Well, it's a good question, and I will be answering it. But I first want to get to something else, which is actually telling you a little bit about myself. We've been on the campaign trail now for quite some time, as you're obviously aware. And I have to say that I am very honored and humbled at the number of people who have stepped forward to support my election. People like Judge Victoria Meadows, who's the current judge of the Mason County District Court. People like Judge Carol Fuller, who used to be a retired judge, who used to be on the Mason County courts as well. There's Judge Stephen Buzzard, who is a municipal court judge, retired, but he's served at times on Mason County courts as a judge pro tem. There's Judge pro tem Stephen Greer, who has stepped forward to support me. He was one of my opponents in the primary, and he's the regular pro tem judge for district court. Additionally, I'm very honored that the Fraternal Order Police Olympic Mountain Lodge 23 has chosen to support our campaign. And the Shelton Police Department Guild has also chosen to support our campaign. And I'm very touched by it. Additionally, there's been several other people who have stepped forward, community people, people like attorneys like Jay Fuller, Christine Langley, Paul Strophe. There's a Cecilia Lazan. There is a Rose Nye, who used to be a port commissioner. And other people in the community, Bill Truax, Nancy Brown, to name some. And I'm very honored that they chose to actually endorse me. Additionally, I've had people on my social media who used to be defendants in my court come out and speak positively about me. And I am very honored by that and humbled. In the end, I think we all want the same thing. We want to see the court continue to function properly and help make this community a better place. As far as about myself, what I can tell you is I've been practicing law now for over 30 years. I've been in all capacities you can think of, just about. I've been a deputy prosecutor for over 10 years in my early part of my career. I've been in private practice now for over 20 years. I hate it when those numbers keep growing, but can't be stopped.
Right.
I've done all kinds of law. Litigation is my primary thing. I've tried hundreds of jury trials, numerous appeals, including 2 to the Washington State Supreme Court, and I have a little bit of federal trial experience as well. I'd like to think I'm more than just a lawyer. So what I can tell you is I've been married now for over 32 years. My wife and I have lived in this community for going on 20 years. We're not quite to 20 years, but we're working on it. I do consider this to be my community, my home. We are active in the community, particularly with our church, St. Edward Catholic Church. More so my wife, but I'm in a helper's role, and that's kind of what we spend a lot of our life about. I have a son and 2 grandchildren, and he has his wife, so it's my daughter-in-law. It's all good.
Very nice. Talk to us. I know there's, for the majority of the population in the county, they would have very limited interactions in a courtroom. So explain to me now what it is like in your courtroom currently, either when you're working as pro tem for the district court or for Shelton Municipal, the speed, how you interact with the prosecutors and the defendants. What's it like in the courtroom?
Well, it's also a good question. I'm going to answer that in 2 parts, my courtroom and when I'm acting as judge pro tem, because when you act as a judge pro tem, For the most part, you're not wanting to deviate from the regular judge's policies. And I'm not saying that Judge Meadows has policies that need to be deviated from at all. But in my court, I treat people fairly. I'm impartial. I keep open minds. Have been referred to somewhat as a disciplinarian. In short, I expect some decorum in my court. So I do have dress codes that I expect people to follow. They're nothing onerous, but shorts, tank tops, revealing clothing, things with inappropriate pornographic or whatever decals on their clothing, I do not allow in my court. Generally speaking, the way that would work is first time they may not know the rules, so I just say next time don't do that. Second time, then it might not be quite as just please don't do that in the future. I tend to be someone who likes to keep my word. So when I release somebody on a promise to appear and they're on pretrial and one of the conditions is always going to be don't commit any new crimes and they get charged with a new crime, I am going to keep my word in the vast majority of cases and set bail. I think it's important for judges to be known that they're good for their word, both when they say they'll be lenient, when they say that there's going to be consequences, so people know what the rules are and people can respect the judiciary. So we handle all types of cases in municipal court. They're all in the criminal realm that we were talking about, misdemeanors, gross misdemeanors. That's the same as district court. We also do traffic infractions. The difference with district court is district court also has a civil jurisdiction as well and does other types of civil cases, such as anti-harassment orders, protection orders, and also many types of civil cases where the damages are $100,000 or less.
Okay.
So that'll be a difference. When I'm in district court, it's usually because of the fact that either the judge is not available, or it's because of the fact that the judge has been disqualified either because she recused herself, or there's been something called an affidavit of prejudice filed. And so I would step in and fill in those roles, when I'm available. And so I can keep going on, but that's basically the way it would work. The way I approach it, again, is I treat people with respect. I keep open minds. There's many times when I went into thinking a case would probably go in one direction, and then I hear some facts that say, no, I don't think it's going to go in that direction anymore. I think we need to look at it in another way.
What are the factors considered in granting and setting bail amounts for defendants, and what are your primary considerations?
Well, there's several. The primary consideration is whether or not someone's going to reappear. And we have access to quite a bit of information by computer, which is a lot different than when I first started. So when a person has a large history of warrants, then the situation is that that's going to be a factor that maybe bail should be set. Although that can be outweighed if they're in court and they showed up voluntarily, then that may very well outweigh that. If they have a large criminal history, that's going to be a factor I'm going to consider. If their demeanor, if they act contemptuously in court or what have you, which doesn't happen that often, it has happened on occasion, that's going to be something that's going to be taken into consideration. We've had situations, and because of the jail overcrowding situation, where we've had people who would get arrested on warrants served, released on a promise to appear by the jail, then not show up and go through that cycle. Sometimes, I think I've counted up to about 15 times when that's happened. We don't deal with it too much more in the city because we have a new jail contract, but it was a real issue, and obviously that's going to have a lot to do with whether bail is set and how much.
Well, let's talk about the growing prison population, the constraints here in the county, as we all know and have heard, and some folks even gone toured the jail, things like that. What can be done, if anything, especially from judgeship, when it comes to the jail and how they have folks in the jail that may need to be there, or there's folks that may not be as high-level offenders or things like that. What are we going to do about the jail situation?
Well, that is also a very good question. What I can tell you is this: from a judicial standpoint, we have to manage the resources we do have. But this is the reality, and I want to preface this and be very clear. I am not blaming the sheriff's office. I am not blaming the jail. There's so much room in the inn, so to speak, and they cannot go past that. And if they did, they'd be looking at saddling the county with a pretty serious civil liability. They have constraints too that they have to pay attention to. So I'm not blaming anybody in the sheriff's office about this. But the problem we have is we haven't had increase in capacity. And as a result of that, we've had many situations now where people who are arrested for crimes like shoplifting and what have you, particularly if they're county and not city, cannot be booked. The reason they can be in the city, if we have room, is because the city has a contract with the jail with X amount of beds are allocated for city prisoners. As long as one of those beds are empty, we can use it. But the district court defendants do not have that same luxury. And for that matter, I should say the district court, for its defendants, is a more accurate way to say it. It's to the point where they're not even able to take in some Class C felonies. It's a serious problem. I've told people on the campaign trail that I have been running essentially 2 campaigns, and I'm going to do it on your time here as well. This is something that's going to have to be addressed. The judges do not have the ability to address it. I can, as a municipal court judge, order construction of a new jail. As a district court judge, I would not be able to order construction of a new jail, nor could a Superior Court judge or anyone else. What I can do is be a voice and alert people to what the problem is, and that is a problem. And it's more than a problem, and I want to be real clear about this. I'm not saying this because I just love putting people in jail. The opposite is true. I hate it. I don't like putting people in jail. It doesn't mean I haven't done it. There are some people who I put in for the maximum period of time. And I'm not going to go into each individual case. We'd be here all morning. But the fact of the matter is, I don't like putting people in jail, but having the ability to have a credible incarceration option is what makes everything else work for people that are otherwise not internally motivated to comply. So, for example, we have a great community service program with the municipal court. The fact is, if people know, and I've seen this with my own eyes, if people know that if they don't appear, there's nothing that the court can do about it because the jail's not going to accept them. They don't show up. They don't meet with the community service coordinator. They don't show up for their assignments on the work crew. If people are ordered to appear in court, and they don't, because they know nothing can happen about it. We've had situations where I've had people taken into custody, and it was reported back to me that the defendants told the police are taking them over to the jail. They'll be back to the city building before the police will, and they were right. It's that type of thing that's been going on. Ultimately, it's a problem that's going to have to be solved, and at some point, I think the first step is I think the public needs to know that there is a problem there, which is one of the reasons I'm uttering the words I'm uttering right now. So I can be a voice, and I've been that voice, or at least the last 4 years, probably longer, as a municipal court judge, and I would continue to do the same thing as a district court. As far as managing with what we have, we do the best we can. But again, it is a real issue when the people who are inclined to be defendants know that there's nothing the court can do about it. There's nothing we're going to be able to do that's going to all of a sudden persuade them to start complying. That's just the reality. But we do things in the city. We have a jail in Forks that we use to take some of the pressure off and use for long-term commitments. That's worked out really well for us. The county, I don't believe, has that type of resource at this point. But ultimately, it's going to come down to people, county commission, and the residents of Mason County deciding what kind of public safety system they want to have.
Talk to me about your understanding about the caseload or backlog that is currently through the court system in the county. Is there a large backup of cases that are waiting to be in front of judges?
Criminal cases, not so much, because they're under speedy trial rules, and they get first priority. And so in municipal court, that part's not a real issue because, frankly, there are all types of cases that are time limited. We have to get them done within a certain period of time. It's not like a civil cases. District court, I've been told that they've not had, at least as of yet, an uptick in civil filings. Although I anticipate that could happen at some point because the jurisdiction limits keep going up for civil filings in district court. And municipal court wouldn't have that kind of issue. Those can be a problem, and they're certainly a problem in Superior Court because it can be very difficult sometimes to get a quick trial date. Most of the time it's not going to happen. In my civil practice, it seems to me pretty rare we're ever able to get a trial date before 1 year's transpired.
Wow.
And again, there's a hierarchy in Superior Court. Of course, I'm not running for Superior Court, so I don't worry about it on the campaign trail. But in District Court, from what I've been told, it's still mostly a criminal traffic infraction and also anti-harassment orders caseload, and not so much the civil as far as taking up the time. They also have small claims cases too, and those are designed to be quick, speedy resolution, and those pretty much are. But there's not that many of them, from what I've been told by, I think, actually Judge Meadows, and not that many that ever wind up actually going to trial in any given year.
What are your views on whether the courts, and this is a generalization of all courts, if you wish, or in some localized settings, dealing with racial or gender bias?
Well, to be perfectly honest with you, I haven't noticed any Mason County courts having that as an issue. I guess it could happen in my court. We treat everybody the same. The main issues we have are people who require interpreters. A lot of people, I assume, are immigrants from Mexico and Central America. One of the primary languages that come before our court now is not Spanish, it's Mom. That usually winds up being the busiest interpreter calendar day we have. We've had to break the interpreter calendars up into different languages because they were just getting too large. But the fact is, I treat them to the extent possible the same as anybody else. Some differences: if you're sentenced on a DUI, you're going to be ordered to attend a victim's impact panel. However, if it's a mom speaker or CONHABAL, I qualify that if such a program is actually available. As far as I know, it's not. Beyond that, I think people are treated the same. People are held to account the same. And my hope is obviously that everybody just complies with their court orders, get the case over with, and move on with their lives. And to a large degree, that happens.
What's your greatest accomplishment in your legal career?
Well, it starts sounding like a braggart, but frankly, I've had a lot of legal accomplishments. And so I'm probably going to list them because there's none I'm going to be able to just say this one is it. I was the first deputy prosecutor in the state of Washington to successfully get the horizontal gaze nystagmus admitted in evidence, as far as I know. And the case I had in Thurston County really paved the way later on with the materials I got and the assistance I gave other prosecutors in other counties to move that forward. That was certainly something I was very proud of. I have tried a lot of cases, including very difficult cases, with oftentimes good results. I mean, I've won a lot of cases, and there's other cases. Well, we just won't talk about those. I mean, any attorney who tries a lot of cases is going to win some, lose some.
Sure.
I'm proud of that. I've written mostly when I was a prosecutor, but when I also afterwards, I've written legislation, some of which became law, and I, lobbied to get it moving forward. There were some major changes to the animal cruelty laws that were done in the 1980s, and that's off the legislation I wrote, and then we lobbied for it and got Senator Kryler to run with it, and it made some definite improvements in the animal cruelty laws at the time. There's been other changes since. I'm not going to claim credit for it because I was out of the picture by then. I wrote an amendment to a law and got that passed, or lobbied to get that passed, that made it easier to get out-of-state records admitted into evidence if they were certified. There was a gap in the law. And I started a process, and other people did as well, but I was working independently, where I wrote a bill, and this would have been in the late 90s, I believe. And what it did would make, if you had a situation where you could be charged with first-degree murder and your victim was someone who had a no-contact or protection order or or restraining order against you, that would make it a circumstance where the prosecutor could charge aggravated murder. Now, I was no longer a prosecutor by that time, but it's still something I felt needed to be done, and it's something I am proud of. I've argued many appeals, two of which I argued in the Washington State Supreme Court. I've done that. I have a federal trial under my belt. I haven't done a lot of federal work, but at least I can say I've done one federal jury trial. Didn't come out the way I would have liked, but it was still a good experience. I'm proud of what we did with that. If I sat here and thought about it, I could probably come up with some other, but I'm not trying to come off as some braggart, but I'm proud of all of these things. And overall, I'm proud of the fact, just my legal career in general, that I have been able in so many instances, both when I was a prosecutor and defense lawyer and civil attorney, to make positive differences in people's lives.
In the last minute or two, go ahead, look at that camera there and tell the voters out there why they should bring you on in the district court.
Well, the reason they should elect me as the next district court judge, first off, I'm endorsed by the current district court judge. But in a word, I have judicial experience. I have a lot of it. I've been the municipal court judge for almost 10 years now. I have a lot of pro tem experience, and I am the only person in the race that has any judicial experience whatsoever. I'm an accomplished attorney. I'm fair. I'm impartial. And frankly, I am the only person right now who is qualified, that's left in the race, who's qualified to take this position.
He's running for district court judge in Mason County, George Steele. Thanks, George.